Hi, I'm Akash, and today we're going to be talking about another form of intellectual property, patents. Now, along with copyrights and trademarks, patents form one of the central pillars of the intellectual property regime, whereas copyrights focus on creative works and trademarks focus on brands and corporate identities. The patent focuses on scientific and technological advancements. So first, let's take a look at what makes a patent. What is, in a sense, patentable?
A patent is a type of intellectual property that protects scientific achievements. Now, this achievement can take the form of a device, a product, or a technological advancement. But it should be noted that a patent will only protect the application of science, not raw science itself. What this means is a scientific discovery itself is not eligible for patent protection. You need to have a practical application of science in order to apply for a patent. Now, patents come in two broad categories: a process patent, which is a patent over the method for creating something, and a product patent, which is an object, an item, or a device. Now, the exact differentiation between a process patent and a product patent can get a little bit fuzzy and has been the subject of some international dispute. So we can discuss that in more detail later on, but it's important to understand these broad headings in order to understand what a patent can protect.
Now, just because you've invented something doesn't necessarily mean that you'll be able to get a patent on it. In order to be patentable, an invention needs to satisfy three criteria. Let's take a look at what they are.
In order to be eligible for a patent, an invention needs to satisfy three criteria. It has to be novel, non-obvious, and useful. Now, to be novel, an invention needs to be one that hasn't been discovered or disclosed before. That means that nobody has got a patent on it, nobody has applied for a patent on it, nobody has published it, and it's something that is not known outside of you and your associates. To be non-obvious, your invention needs to have some inventive step above and beyond that which is already known in your field. Now, the standard by which this is judged is the person ordinarily skilled in the art. So, for example, if your invention is in the field of radiology, if someone ordinarily skilled in radiology could easily intuit the discovery that you're trying to get a patent over, it will be considered an obvious patent, and you won't meet this criterion and won't be getting a patent. So it has to have a step above the currently known state of the art. And finally, an invention has to be useful. That means that it has to be capable of industrial application. You have to be able to make something useful from it. A frivolous invention that won't deliver any result or is impractical to be applied in the industry generally will not be eligible for a patent.
So as you can see, a patent is a useful form of intellectual property when you're looking to protect your inventions or scientific discoveries. To figure out whether your work can be protected by a patent, consult an intellectual property attorney.
Thank you for watching. If you like this video, please like, comment with your thoughts, share it with friends and family, and subscribe to see more content.